Skylar Croy is standing by from Wisconsin Institute for Law and Liberty to talk about, we got a couple of things that Will has been doing that we're going to talk about on the show today. But this one is the Wisconsin Institute for Law and Liberty taking it upon itself to challenge the American Bar Association. Furthermore, the Wisconsin Institute for Law and Liberty is also challenging a Minnesota judge. And we'll let Skylar explain what's going on. But basically, I'll sum it up at 50,000 feet. The American Bar Association has created a program for lawyers that's racist. Welcome back, Skylar. Thanks for joining me.
Vicki, it's great to be on. Thanks for having me.
So the ABA is racist, and the reason the misconduct complaint has been filed against the judge is because the judge has participated in the racist programs of the ABA, the American Bar Association. Why does it matter what the American Bar Association does? What does that mean to a lawyer that the American Bar Association does X, Y, or Z?
Well, to provide some context, the American Bar Association is a really big deal in the legal profession. It is one of the largest, if not the largest, professional association of lawyers in the country. It is famous for, among other things, grading judicial nominees. So when you ever hear that someone was rated qualified or unqualified or highly qualified to become a federal judge, those ratings are from the ABA, and they are often influential in terms of presidential nominations and whether someone ends up getting confirmed. Now, taxpayers should care about the ABA, not just lawyers. And the reason taxpayers should care is because the federal government gives, through various programs and various agencies, millions of dollars, many millions of dollars every year to the ABA so that it can do all sorts of various things. And we are very concerned about 9 particular programs that the ABA is running. And those programs use race quite explicitly in their criteria for selection. And one of those programs, as you alluded to, is a judicial clerkship program. So a clerkship is basically just like a young lawyer who works for a judge. The ABA has annual job fair where they help judges meet so-called diverse candidates. And that just is a euphemism for race, which is very clear.
Right, it's non-white. Diverse means non-white. Right? That's what it means. Exactly. So the clerkship program is not for white people. And then you have a bunch of other programs similar, another clerkship program, and a number of other different opportunities. What does it mean for a lawyer to get a judicial clerkship? Is that a big deal?
So getting a clerkship is a very big deal. It's often considered the first step towards an especially prestigious career. I'd have to look up the exact numbers, but if you look at, for example, at the 9 U.S. Supreme Court justices, I would guess most, if not nearly all of them, had a clerkship at some point. And this is why it's very important that those clerkships are given out based on merit. And as you mentioned, one of the things we did was file a judicial misconduct complaint against federal judge in Minnesota who has not just participated in this program, but actually been involved in various leadership positions over time. And the ABA asks judges who attend this fair to make a commitment to hire a specific number of minorities. And that is problematic because the Judicial Code of Conduct says explicitly that judges will not discriminate on the basis of race. And that's exactly what's going on here.
Yeah, and the ABA says it's okay to discriminate on the basis of race, and that's in violation of federal law and every state law on the planet. And so when the ABA says it, when the lawyers say it, when the people who are expected to uphold the law say it, Yikes, right? And there's a diversity fellows program and the business law program for LGBTQ lawyers and lawyers of color and the legal opportunities scholarship program. And that's $15,000 to, quote, diverse law students, which does not include white people. That's Black, African American, Native American, Hispanic American, Asian, and Pacific Islander. The diversity clerkship program we've got here, the judicial intern opportunity program. No white people should apply to these things because you're not going to get the scholarship or the clerkship or the opportunity or the internship.
Well, and let me add on something. So today, the ABA put out their press release in response, and it's really quite striking in a number of ways. And one of the most telling parts of that press release is that the president, I believe it was the president of the ABA, just flat out said, we think the legal profession needs to look more like the nation's population. Now, of course, they don't go on to define what they mean by that with any specificity, but let's be clear. That means the ABA wants to take affirmative steps to decide who gets to be an elite member of this profession and who doesn't, and that the way they're going to do that is to use various demographic data, and they're going to try and craft it to what they think it like.
Where does merit come in? Where does merit come into any of this, Skylar?
So merit at best is being used as kind of a secondary factor after people who are eligible have met the basic eligibility requirements.
Being black, for example, or being gay, or being trans, those are the basic eligibility requirements. Breathing in and out, having a law degree, and then checking some diversity box, right? That's basic.
Correct. So, for example, one of the ones that I thought was the most shocking for the Judicial Intern Opportunity Program, and I actually started to go fill out an application for it just to make sure I had my facts in order here. The very first thing that happens is you go up to a screen on the website, and it says, this program is for minorities, members of LGBT communities, and a couple other traits. And then it says you have to check a box saying you acknowledge that. And then you also have to say that you read a form that actually provides very detailed, very specific definitions of who qualifies for different racial categories, right? Specific definition for what it means to be Asian or American or whatever it is. And then after you have to do all that, you have to check a box that says you self-identify as being from an underrepresented community. And then you have to check another box that actually says which one of those communities it is. And it literally is box checking based on.
So there's your preliminary merit is if, a bunch of underqualified people based only on the immutable characteristics of their skin color. If those people, that's first. So you can be totally underqualified. But if those are the only people who apply, then we take that group of people and then we select from that group of people. And it could be totally possible that none of them are qualified to have a position as a judicial clerk or something like that, isn't it? We're seeing that with UCLA Medical. That's the reason I'm bringing this up. UCLA Medical did the same thing in 2020. And in 2023, 52% of UCLA Medical students can't pass basic medical exams on basic stuff. So when you do this, you automatically, and you take merit off the table, you've automatically reduced the quality of the lawyer, the doctor, or whatever.
Well, and it's not only reducing the quality. I mean, reducing the quality is dangerous, but let me share what I think the more dangerous, sort of sinister part of all of this. If the legal and the medical profession, but especially the legal profession, if to get to certain points in your career, you have to subscribe to certain ideologies and you have to support DEI and all of these other acronyms and everything else, that shapes the very fabric of the legal community. And I don't think it is any secret that the legal community is substantially, on the whole, left of where the average American is.
Sure. So you can imagine, and there's already been arguments made academically, at least, that certain categories of people don't deserve a defense. Certain types of people don't deserve constitutional protections because they're bad people, because they're MAGA, because they're, whatever. They've been defined as, somehow unworthy of rights that all Americans are guaranteed. That's been published in academic papers. So now imagine if this becomes the reality of lawyers and you have to hire a defense attorney or you need someone to take up your civil rights case. If I don't check the right boxes, am I going to be able to expect adequate representation in a couple of years or, a handful of years?
Let me give a great example of that. Once upon a time, the ACLU was famous for taking cases defending not just people on the left, but people on the right who were being accused of absolutely heinous things. And they did it on principle. You don't really, occasionally, but that kind of thing is a lot rarer than it used to be. If you look at most of what a lot of these left-leaning litigation centers do, it's not just about principles. It is about advocating for very specific causes, and they are pretty skeptical of taking cases where it involves someone on the right doing something that they don't like, even if on principle they should be for it.
Exactly. The ACLU has stopped doing that, I think, almost entirely. We rely on, groups like Will or something to defend not heinous acts, but just basic free speech protections. The ACLU used to do that. That's over. I hope you're successful. This is a Title VI complaint filed, so a federal complaint filed on both the judge and the ABA. And then I assume you just wait and see what happens after that before you decide whether or not to take the next step, correct?
Exactly. So the Title VI complaint went to both the Department of Education and the ABA, and the Department of Justice, because both of those agencies are involved in funding the ABA, but also the universities that participate in this scheme because they're involved too.
Taxpayer-funded universities, yes.
So we did name 3 universities in this as well. And I suspect there are probably closer to 20, but there were 3 that I could confirm for sure had helped facilitate this program. So they got named as well. Yeah. And if I find out that others were involved, they'll be named too.
Skylar Croy, Wisconsin Institute for Law and Liberty, thanks a ton for coming on today.
Thank you so much.